Добрый день, дорогие
Good afternoon, dear friends. On behalf of the Institute of Law and National Security of Russian Academy and RANEPA, we cordially welcome you at the Gaidar Forum 2020. This year, it is 5 years of the foundation of Eurasian Economic Cooperation Union. 5 years is quite a term, but on the other hand, is not a very long term. But nevertheless, that's the period after which you can review the first results, to review the development of the integration. And we would like to discuss the issues of the law and legal developments issues, and to maybe look away into the future for the prospects of our economic union. And I am introducing the participants. The moderator of this section will be the only lady here at the table, Ekaterina Alisievich, head of the chair of law of the Department of Law of RANEPA. Kishkembayev Askar, head of the Secretariat, member of the Collegium of the Minister. You know that in the Eurasian Commission, the members of the Collegium regarded as ministers. So he's dealing with financial policies. Vladimir Taraskin is the head of the legal department of the Eurasian Economic Commission. Zholymbet Baishev, he is the chairman of the Court of the Eurasian Economic Union. And Anatoly Kapustin, a prominent scientist and scholar, and I'm sure many of you are acquainted with his works. So Anatoly is the first deputy chairman of Legislation Institute at the government of Russia. And we were very much surprised and happy to say that practically we have in the room half of the membership of the court of the Eurasian Union, and I'm happy to introduce two courts from Belarus, Fedorov Alexander and Denis Kolos, and also a judge from the Russian Federation, Konstantin Chaika. Thank you very much, colleagues, that you've managed to attend, to participate in the discussion. So I'm giving the floor to the moderator of our section. And sorry, I forgot to introduce myself first, Alexei Smirnov. I'm the deputy chairman of the National Security Institute. And we also have the director of the institute, Stanislav Mogilevsky. So I wish you fruitful discussion. And I think that today will open up your eyes to different aspects of the activities of Eurasian space. Thank you. So, dear colleagues and participants, good afternoon. Thank you very much, Valery, that you have introduced the respective speakers. And I will start with briefing you on the procedure. So we will have 2 hours of discussions, and we are planning to finish at 4:30 p.m. So we are going to do it as follows. So we will give an opportunity to every of the speakers to speak up. If the participants have questions after each presentations, there will be an opportunity for Q&A. But after all the statements, we will have the Q&A session, and you will have an opportunity to ask questions to all the speakers and also the members of the court, and you can also ask them. So thus, we will start our work, and I'm very happy to give the floor to our first speaker, Vladimir Taraskin, Director of Legal Department of Eurasian Economic Commission. Thank you very much. Thank you very much for the invitation to participate in the event. Well, I will brief you generally on the legal system, which has been built up because of the formation of our Eurasian Economic Union, and possibly about some prospects that we currently can see and are planning to implement shortly. So the Treaty on Eurasian Economic Union was signed in 2014 and became valid as of 2015. So respectively, it covered 3 countries. Initially, they were the initial sponsors, and then further on in 2015, they were joined by Armenia and Kyrgyz Republic. In accordance with this treaty, there was Eurasian Economic Union was set up as an international organization of economic integration. And here, of course, we should pay attention to the fact that it was not just for nothing this norm was included. It was an attempt to show that Eurasian Economic Union is not a standard international organization. It's an organization which claims to integrate, to set up or create integration of space, similar to a certain extent to what currently is created in the European Union. Certainly, the way it functions and in the European Union, I think we still have to work to reach it, but of course, this kind of provision in the treaty says that the organization does have prospects of development. When this treaty was written, it did include a big number of international contracts and agreements which had been concluded in the period approximately from 2007 when the process of developing of customs union had been outlined, and the conditions of single economic space. Then they included the provisions that were valid during Eurasian cooperation unions. The main condition was to set up conditions for free flow of labor products and to pursue aligned policy in a number of industrial sectors identified by the treaty. Here, of course, all those words are meaningful: coordinated, single, aligned policy. Because according to the text of this treaty and the appendices it has, we can see that in some of the parts, the regulatory part shows the direct meaning, I mean the norms in the field of technical regulation and customs regulations. And the Commission and the Union thus have the right to issue acts and decrees. In some of the spheres, like macroeconomics and some other spheres, the Union, in the majority of part, the competence is to coordinate or getting aligned and the policies pursued in the member states. In this respect, there's one of the drawbacks in the treaty, meaning that to a larger extent of the functionality of it and functions that are postulated and given over to the European Economic Union, the majority of those competences and authorities are in the alignment and coordination sphere. I think we should draw also attention to the fact that despite all this kind of institution, of course, there are a lot of economic unions and customs unions in the world and of different types, so different associations, but by the degree of association and transfer of the regulatory authorities up to the above national level, that we are lower only than the European Union. Of course, their competences and authorities are written in more details, and but still we are number 2 in the world, and I think that's quite an achievement of both the states that had prepared the treaty and the developers of the treaty. This treaty introduced such a legal category as the right of the Union, or the law of the Union, which is a novelty also, because in the previous integration projects that had existed among our countries, between the countries, we didn't have this norm. And Article 6 of the treaty enumerates the sources of the law. It's the Treaty on the Union and the agreements concluded in the framework of the Union and between the member states. And also the agreements concluded with third parties and countries, and also an act or decree on Intergovernmental Council and Eurasian Economic Commission. Totally inside all those sources, the treaty sets the hierarchy of those acts among themselves. Actually, this was done aimed at the treaty to include a big number of decrees and acts of both the customs union and the single economic space, and some of the acts that used to be at the level of the Supreme Council, which had been postulated and provisioned at that level. So this kind, they all have been incorporated. So this kind of distinction by importance seemed expedient to the developers. More or less, it's clear that the treaty is of the highest validity. Then goes the agreements concluded inside the Union, and then intergovernmental commissions, and the Council of the Union, and the Commission, and the Collegium of the Commissions. Well, the contracts concluded with third parties are somewhat at the side, saying that they should not contradict the main principles and ties postulated in the Treaty on the Union, which means that as for the details, during a negotiation process with third parties, it means that you might distance from some of the details of the conditions of the treaty. A very important element of the source of law, well, and of course international law, and I would like you to draw attention to the fact that the treaty also has a novelty which was absent there in the previous integration documents, and now that's the right of the Union to independently conclude contracts with third countries. The details and mechanisms of such conclusions and the procedure of concluding this kind of contracts is provisioned in the procedure of of contracts concluding, which was signed in 2018 and became valid on December 16th of 2019, which is quite recently. So that agreement does have its own nuances, which stresses some of the nuances and the stages we're currently in and phases we're in. This kind of contracts say that they are to be concluded as one party. For instance, when we did it with China recently, and with some other countries, So it means that concluding this kind of agreements with third parties by one union, which is postulated and provisioned by the treaty, but say far postponed and delayed to a later date. We will try to do it this way because there are a lot of other nuances related to legitimization of this kind of contracts with third parties, and if we were concluded them only on behalf of the union. So besides those contracts, as I mentioned, there's a big layer of legal system is covered by the acts of the authorities, which is the Supreme and the Intergovernmental and Commissions, which consists of the Commission Councils and the Collegium of the Council. The Supreme Council consists of the members of the Supreme the presidents of Russia and Prime Minister of Armenia, and the Supreme Council issues decrees and instructions and on the norm, and respectively the Intergovernmental Council consists of the chairman of the governments and also makes decisions and issues instructions. So the acts of the Supreme Councils and the Intergovernmental Council, as is said postulated by the treaty, they are enforced by the member states, and notably in our legal discussion, we should pay attention to the fact, because formally speaking, in some of the countries, specifically in Kazakhstan and Armenia, at some point when those states had been joining and were making their decision to join the union, they had issued certain conclusions of their constitutional courts. In accordance with those decisions, it was provisioned that acting in those countries should be postulated by the acts of the Commission, and the authorities of the higher authorities, they were not part of it. And in this respect, this norm does exist, but in other countries, the decisions of those authorities are enforced directly if they don't have postulated otherwise. And so this kind of acts then are enforced directly and are legally valid. So then, about the acts of the Eurasian Economic Commission, which consists of the Commission consists of the Council and the Collegium. The Council is an intergovernmental authority or a body, because it consists of premiers and the number ones of the governments, and they periodically meet, playing the role of intergovernmental body, and they make their decisions as a consensus. So they mostly make the most important decisions. For enforcement, you have to bear in mind that those agreements and the Treaty on the Union and the development contracts, as a rule, they postulate it that this kind of regulation is implemented by the Commission, but you have to bear in mind that this kind of reference in the general case always means the Collegium. But if otherwise is not specified by the procedure approved by the Supreme Council, which has an exclusive list of questions for the Commission, which is adopted by the Commission. So this list is quite limited, but it is growing. But the general message is that the main focus should be not on the intergovernmental body, which is the Council, but the Collegium, which is purely above national authority, which is made up of, as was already mentioned, of the ministers, which represent the member states. And the member states are not entitled to instruct those ministers to vote in this or that way, and the ministers are not do not have the right to request the positions of the countries they represent. So formally, the treaty envisages that the ministers and the Collegium of the ministers should be exclusively an above national authority and perform the above national functions and sort of to be the citizens of the Union. Unfortunately, it doesn't happen this way all the time, but ideally this is right. And as far as I know, in the European Union, they have the same practice. Another way of sources, but unfortunately not postulated in the treaty, but of course we should, I think, do it. It's the conclusions and the injunctions of the court, though it is not postulated because it is not court of law. It's even in some of the substantial things, some of the positions of the court are of great significance. For instance, I don't remember when, but well, at the very onset of the court activities, maybe back in the 2015, there was one injunction that, one ruling that, which in some of its parts said that the Commission is not entitled to reversely delegate the authorities given over by the state. For instance, so this kind of, and very often, well, previously, it happened in the way, for instance, the nuances of the procedure were reversely given back to the countries, and the Commission sort of adopted a general document saying that the countries, the member states, will decide on the nuances. One of the issues was reviewed by the court, and the court ruled that it wasn't right. And in the future, after we received their position, we in the Commission, and I hope, well, actually, we drove home to all the member states and the countries that cooperate with us that if the authority is delegated, it is not to be delegated back. Also, another thing to draw your attention to is that despite the fact that the Commission and other authorities and bodies and the Supreme Council and Intergovernmental and the Council of the Commission, those which are organizationally serviced by the Collegium, of course it's above national, but nevertheless we arranged a procedure inside us, which and the procedures which to some extent are present in those countries and even in some of them. For instance, if it is about the assessment of the regulating impact, the public discussions and hearings of our projects, we do have all those two procedures in place, and we publish the projects beforehand, especially those about business development. We do the impact assessment procedures attracting the business communities of the countries. Now we are discussing a question for us to introduce. So far we are experimenting, but we are going to introduce this impact assessment procedure into the international treaties which the member states are concluding. And to a large extent, formally speaking, I think they are to organize this kind of procedures inside, because they are to sign them.
But nevertheless, I think there is a consensus opinion saying that if this regulation activities are going within the framework of the Union, then it means that we need to organize this procedure within the framework of the Union. So, in conclusion, I would like to say that actually the regulation, the law system of the Union is articulated by us through mistakes and tries process. It is not ideal, and there are a lot of legal questions here and technical questions that we need to tackle, including those, including political things. Yes, there are some political issues related to the level of preparedness of various countries for integration. But this work is underway anyway, and as of today, I'd say that this regulatory system, Eurasian regulatory system, is a comprehensive complex of intergovernmental regulation and supranational regulation. So some things are tackled in a similar way, as if they are intergovernmental consultations or commissions with implementation into the legislation of member countries, and implementation of and making on the level of the European level, having the role of a coordinator and a harmonizer. So we try to harmonize legislation, or at least stimulate countries for this. And in some questions, we are acting as a real supranational body, a government of 5 countries. And at the recent stage, to say what is dominating, I think the first, we'd like to have the latter to dominate, since we're working in the Eurasian Committee. But anyway, first step is very important down this path. As for the prospects, as of today, among the most important things, we are working on preparing the strategy of deepening European Eurasian integration up to 2025, and this is a concept document. It will be of indirect impact. It'll be a concept or a strategy that will contain and define the main points that will be articulated in the future through changes in the basic agreements and preparation of new documents for development of the strategy. Unfortunately, today, this work is on the stage where I cannot tell you precisely in this report how will it look like and how will it will go, because the interstate intergovernmental consultations are still underway. But this document will anyway be articulated, and it'll be a step forward in developing of integration and development of the legal system, and it will show that integration is not going backwards, is not stopping, but depending on the results, through larger, smaller steps, it anyway develops. Thank you very much for your attention. Vladimir Ivanovich, thank you very much for your very insightful presentation. It opens up a lot of opportunities to ask questions to participants of our panel. So if you have questions now, you can ask them. So the volunteers will help you with that, and they will pass the mic to you to ask your question, so for everyone to hear your precisely. And I see a question in the audience. Vladimir Ivanovich, a question on your presentation. Please use a microphone. Sorry, no microphone. So the regulation nature is going to both types of documents, both the teamwork operations and the council. The documents can go in three types: the decisions, recommendations, and decrees. The decrees, decisions, they are of normative nature, and the decree is for organizational matters. We try to avoid normative recommendations in them, and recommendations are going as recommendations. Those are acts aiming at development. Usually recommendations, if we enhance this point, well, the committee in general, if you see it in the agreement, has a limited scope of responsibilities, even narrower than that of the national governments, because we are looking not at areas of regulation, but specific provisions in the agreement on the union or other agreements that actually instructs the committee to issue a document. So if there is no recommendation to take an act, we do not do it. Comparing against national governments, sometimes they make decisions on various areas of competences. Thank you. Thank you. Another question, please. You're welcome. May I? Thank you very much. If I may, I will not stand up. Professor Machulskaya, Law Department of the Moscow State University, Labor Law. So my question is about pension coverage, which is related to the freedom of movement of a labor force and accumulating the labor period and the pension conditions. So pension systems of our countries are very much different one from the other in all parameters, across all parameters. And as far as I know, this agreement is being prepared and will be soon signed. Could you please comment on that? You know, my colleague, minister, not only on financial markets but on social policy as well, and my colleague is also the leader of the Secretariat of the ministry. So please, the floor is yours. Thank you very much for your question. Indeed, the competence of our bloc in economy and financial policy is part of social area. And about your question, the agreement on pension coverage, yes, this agreement has been developed in the course of a couple of years. It was a difficult, complicated process, and you properly put it, pension systems of our countries are different one from the other. Nevertheless, this work has been completed. The agreement was agreed upon by all countries, and it was offered for discussion for the Council. And at the last meeting of the highest Eurasian Council meeting in December 2019, this agreement was signed. At the meeting of the highest Eurasian Economic Council, so it was signed by the heads of our countries. So it will take come into force, and the ratification procedures will start in the member countries. And after this, I will also touch upon it in my presentation. But just for your information, I would like to congratulate all of you with signing one of the key documents regulating social aspects of our integration and implementing one of the four key freedoms of movement of labor resources, and it is signed. And I hope that by the end of the year, countries will implement the ratification procedures, and all the necessary documents will also be adopted. And you can have a look at the text of the document on the website of the Commission. We published it yesterday. Yesterday we published the document. Thank you. And now I'm giving the floor to our next presenter. With pleasure, I'm giving the floor to Baishev Zholymbet Nurahmetovich, head of the Court of the Eurasian Economic Union. let me say thank you very much to all the organizers for the invitation to participate in this meeting. So the timer, could you please start the timer for me? 20 minutes is my limit. I will try to stick to this time slot. I would like to say that I'm very happy to speak in this audience, because in this room, because I had my PhD, defended my PhD here, and this is my alma mater, and this place I think will help me when presenting. So first half of the day we participated in the session devoted to Mr. Gaidar, and the discussion showed how in Gaidar forum people usually discuss things in a very free manner, liberal manner, and various people talking to each other, arguing about things they discuss. Of course, I have my prepared presentation, but I will speak outside of the slides. So it is a very typical thing that when the moderator started the session, she said that half of the court members is here quite unexpectedly. Well, I'm not asking you to vote, but if I ask you what is Court of Eurasian Economic Union, if I ask you, do you know what this court is all about, probably you would say no, we don't. And that's not surprising. During coffee break together with our colleagues, we met a person who is representing a member country who didn't know anything about the court. Another person, a foreigner, heard a couple of things about the Eurasian Economic Union and the Commission, but never heard anything about the court. And this is quite typical. I face such situations when we participate in such fora. That's the reality, but that's not right thing to have. If we're speaking about Eurasian integration, well, some people do not know that this process comprises of 5 countries: Russia, Kazakhstan, Armenia, Kyrgyzstan, and Belarus. And now Uzbekistan plans to join, and Moldova is an observer. Some people do not know about the Union at all, what it is all about. Some people just know about the Commission, but do not know about other bodies of this Union. So, previous speaker has touched upon many things already. I just want to try and, well, with all these points arising, I will try to answer a couple of questions that will clarify the whole picture. What is this court all about? Why we need it? What tasks it tackles? And what are the prospects of it? Trying to answer this question, I would like to first of all say who we are and what we are representing. First, what is this court all about? Eurasian integration was, and the agreement Vladimir Ivanovich mentioned, was done in a similar way with that of the European Union. But if I ask the audience what is the European Union Court is, probably the majority will say that they know what it is. Those who study international law know very well that that European Union is a very successful integration thanks to the law, the court of the Union. So documents, yes, and agreements regulate some things, but court did a very good job in regulating a lot of things during the integration, and it sets the areas for integration and tackles a lot of things. Well, some people say that the law has that the court has too wide competence, but all researchers say that integration can be realistic and robust if this integration has the court inside of it that defines where the process is going and what the legislation is, what the regulation is. So the status of the court says that the implementation of the law of the Union is monitored by the court. So the regulation is the documents, the agreements that should be applied by all 5 member countries in the similar manner. And this is a very challenging task indeed. You all know that if we have 2 lawyers, we have 4 opinions, and the same thing about member countries. The same provision of an agreement can have 5 different opinions from the 5 member countries. So one member state understands it in this way, the other in the other way. So the department of Vladimir Ivanovich tries to tackle such issues through negotiations between countries, but countries sometimes say, we understand this provision in this way, what should we do? They go to us for a consultation. Member states can also go to us for consultation. So it is the interpretation done by lawyers. We offer such conclusions, legal conclusions. Over these 5 years of operations, we offered about 15, 17 consultation conclusion. This is not something you can just take as it is. This is a judgment that covers from 40 to 50 to 70 to or 80 pages A4 document. So this is a large amount of work, and so we need to articulate the positions from the member states, and the court should actually articulate the position. It cannot avoid articulating it. As Vladimir Ivanovich said, so the court articulated its position, and we stick to it. Speaking to a conference we had in Minsk in September, the Minister of EAEU on Trade said that what the court says is the focus for us, is the benchmark for us. When colleagues say we will do this and that, they are also thinking about how court will take it, will perceive it. So these consultative conclusions that are actually recommendations, they streamline the regulation of the union in proper manner, and other bodies also look and monitor at these conclusions. So they are mandatory for implementation for all member countries and the country that went to the court for such conclusion, and these documents become part of the court acts of member countries. The Supreme Court of the Russian Federation had a decree recently, and the plenary session of the highest court, Supreme Court of Kazakhstan. And these documents say that in customs relations, if the court of EAEU articulated its position, then the court should stick to this position. And thus, we, through member states and law enforcement practice, we impact the regulation of the union. So just to understand how it works in real life, in June we looked at a case. We covered about 13 cases. Any entity can come to us, individual entrepreneurs or companies, small or large companies, not just the member countries, but their economic actors. So member states and the courts, including Supreme Courts of member states, should not doubt the court decisions of EAEU court decisions. So they need to apply it as it is. The only level where the judgment of a court can be disputed is our court. So member countries can come to us to dispute a decision. Usually it is related to customs classification. In ship trade, for instance, this is a Russian company. It disputed the customs classification in diesel engines for vessels that were supplied from China to Russia, and the Commission decided that these engines should be classified in the position which is actually meaning the duties. There are engines that push forward the vessels, and the duty is 0. But the Eurasian Commission said that the classification should be different, where the duty is actually fixed, and they came to us and said that this is the wrong decision. All courts of the member states had this case of this company, and they got rejection everywhere. Member state courts should work in a way the court of EAEU prescribes, but So the initial decision was not in line with international decisions and international standards for classification of the engines. This decision became the basis of, just 2 weeks ago, I received the draft decision of a council meeting where they made decision on taking it void and excluded from the list of acts of EAEU of this particular decision. And the reason is that according to the decision made by the court, this decision should be taken as void. What does it mean for companies? Well, they lost their money, they went through all these stages, but the decision of our court, together with EAEU decisions to make void the previous decision, actually allows them to go to their courts again to revisit the decisions made before and return the money, recover the money they spent after the initial decision was made. So that's how the operations are structured and how the decisions are implied in member states. So I want to articulate one important thing. The Court of EAEU was created not because it is trendy to have an international court in your structure. It was set up for all member states and companies and regulating bodies like Eurasian Economic Commission to be in line with the provisions of the agreement. And we also had a case in our court of a country against another country. One country of an EAEU went to court saying that the other country is not in line with the provisions of the agreement and some other documents, and the court said yes. The court said no, they really do not compliant. So the court, through their decisions, actually make member states be in line with all the documents signed before. So the court is the body providing compliance for all member countries. Another point, the decisions of the Commission, about 1,000 decisions, should be in line with the documents adopted by the Union. But if a company thinks that their interests are violated, they can go to us. And still we are here now. We received a case from a company, from an entity from Russia for our monitoring, and another case has just been received related to gold, and we have 2 cases in production now from various entities, and so far we have 4 entities addressing us to protect their interests and rights in the court of EAEU. So the Court of EAEU is important not only to ensure implementation of the contracts of agreements, but to protect the rights of various entities. Well, among such entities, we can have foreign investors, and people never invest into an integration or an entity where their rights are not protected. And investing money into a member country or the EAEU, they just want to know whether their rights will be protected effectively. And so we 10 people, 2 from every member state. We were appointed by the president for 9 years. So these judges I'm talking about are independent from member states. I know situations when judges vote against decisions made by the countries they are coming from. So judges should be objective, and we just abide the contract, the agreement of the Union. So international investors look at such courts and their competences and opportunities to dispute things, and they see that their interests can be protected. The role of the court in protection and development of Eurasian Economic Union is obvious. And the question I asked, how the court is articulating the law of the Union. Well, first of all, law enforcement and compliance. But in the decisions we make, according to the addresses and requests from various entities, and that's what the agreement says. We are going to the court, and we invite all stakeholders and the entity, and we actually articulate our decisions. We show all the reasons. They are published on the website, and so all these provisions we articulate for implementation of various rules of the agreement.
And the courts of those member states, when they do similar cases, they use the court rulings. That's the enforcement. And the advisory ruling, which is legislatory. But we express the positions which are accepted by the Eurasian Commission while they are doing the new agreements, and also member states, ministers of justice and courts. So what are the results and prospects for the court? Of course, number one question is the court. I'm talking a lot about it, but what has it accomplished? More than 40 claims and applications, 13 injunctions we did, and 16 advisory appraisals, and 3 cases now pending, and the 4th is coming. It's quite a lot for international court. One case which currently is pending on anti-dumping investigation, well, it covered 23 volumes, but totally it's about 50 volumes. And the judge is here, and we are going to do it in the first instance court. So there was a question on the dumping when the rules of monopoly activities are violated in the territories of 2 countries, Russia and Kazakhstan. 2 companies which are doing the same or similar activities in medical equipment. And when those companies, the company of Kazakhstan addressed the Kazakh facility for this kind of service, and they quoted the price, and they compared it with Russian, and it turned out to be twice as high, and they said, okay, we are going to Russia. And then when they did, they said, well, no, go back to Kazakhstan. And that's a question of monopoly activities and free flow of labor. Isn't it the separation of the market or the splitting of the market? So all those questions are rhetoric, and I'm not giving deliberately the answers. I'm a judge, and I am posing it the way the claimant did. So we are going to review this case. So those 2 companies are now administratively liable, and we conducted an anti-dumping investigation, and I think the 3 companies even were involved, and their managers. And another question: if we do have a postulation that they can address us to protect their rights, but we don't have the provision that physical entities can do so, but they are now administratively liable, and it cannot be challenged in national courts because it was the above national authority. So maybe I think the question is that we have to improve this thing to provide this right to physical entities to go to court to protect their rights. The results can be characterized by the response of those officials which sent us greetings, specifically Mr. Putin, the President Putin, when we did one case. He said the court of the Eurasian Economic Union now is very effective, and they are objectively solving some interstate disputes, which is interstate. That's the word. The first president of Kazakhstan, Mr. Nazarbayev, and president of Belarus, Lukashenko, and the chairman of the Councils of Federations, Matvienko, and the president of Armenia, they all sent us greetings for our conference and positively evaluated the activities of our court. And they stressed the necessity and the role of court to further develop the integration. Just recently, mass media published the address of the president of Belarus, Mr. Lukashenko, because as of January 1st, they are going to be the chairman of the Eurasian Economic Commission. And he has outlined the strategic objectives he has to be developed and solved. And number one, I was satisfied to see the institution of court is welcomed and greeted, and Mr. Lukashenko thinks that it should be expanded, and its decisions should be must become mandatory, and to delegate the Commission the right to go to court. And the Commission now is entitled to go to court on advisory appraisals, and it is while monitoring of the enforcement and to issue the prescriptions. But the member states don't react, and the Council doesn't have the mechanism in place. It used to be there. While the Commission could go to court, and the court could enforce. Same is done in the European Union. So I think this is the mechanism that is proposed by him. And the more rights the Commission has, the higher will be the role of court. Thus, I would like to recap saying that, first of all, the Eurasian Economic Union does exist. It covers the economic potential of 5, and this year Uzbekistan will join it with 6 countries, and it's number 1 on the number of population and number 2 in the world in economics. This union, for it to be effective, we must have the court, and the role should be upgraded while the integration goes forward. Thank you very much, Zholymbet. Time flies, and allow me to give the floor to the next speaker. And after all the statements, we will get back to the discussion. The next speaker is Askar Kishkembayev, head of the Secretariat, of the member of the Collegium, a minister on economics and financial policy, and doctor of legal science. Thank you very much for your welcoming words. I would like to say thank you to the organizers for the invitation to participate in the discussion, and to highlight the issues that the Eurasian Economic Union is working at, and the Eurasian Economic Commission specifically. As you know, the process of integration of our countries into the Eurasian Economic Union has started not from nothing. There used to be some process of integration, creating the zone of free trade and the customs union as of 2010, and 2012. The next stage of integration as a single economic space was developed, and the final stage, which came down to the Astana Agreement in 2014, 26th of May, which regulates that as of January 1st, 2015, we will live in the conditions of new realia, which is the Treaty on Eurasian Economic Union, which is an integration facility with 5 countries, and it has the rights and competences and policies and bodies of an international organization, and being in the process of creating of our legislative activities of the treaty. And I recollect how difficult the negotiations were, and how the Supreme Council had set a task to sign on this the codified single treaty on certain date, covering all normative base of Eurasian Economic Council and Customs Union, and the new agreements that had been developed during the working process. The treaty itself has postulated four main freedoms of products, goods, labor, and labor force, and we have been implementing different freedoms in different regimes of framework. It's full-fledged, or we're just in the developing to implement this or that thing. So in the customs union, as of 2010, we used to have freedom of goods, and that we introduced the single customs tariffs. We were obliged not to defend or protect each other from each other, and so we opened up the markets of each other for the goods to flow freely. And then it went down to freedom of services, of service flows, and we are working at it, which is quite a global assignment. But I would like to mostly talk about one of the key freedoms, critical freedoms, which is labor resources, free movement. And I'm sure every one of us, of the citizens of the Union, can feel personally, which is a social aspect of integration. What has been accomplished and what's in store for us is one of the most important tasks of our economic integration. And in 1994, the first president of Kazakhstan, Mr. Nazarbayev, had articulated the idea. And using this opportunity, I would like to inform you that shortly, we are going to have a lecture of the first president, Mr. Nazarbayev, and there are 1,200 seats, and you can get registered. And it's in 2020 we are going to review the results of this economic integration. So free flow or free movement of labor resources and the creation of a single labor market. That's what was postulated in the treaty, and the citizens of the countries got this right to be employed in any country of the Union. And with no limitations postulated by the national legislation to protect internal or domestic labor markets. The preferences of the citizens and the workers and the members of their family made them equal in the labor market, and the majority of the part focuses on their social security and employment, and also social insurance, which has the same conditions and the same procedure as for the citizens of the countries. There's mandatory insurance for temporary unemployment or maternity leave or professional diseases or incidents. The insurance term, labor term, is calculated as the total term, and the social insurance, but for pension, according to the legislation of the countries, and also emergency medical help is provided in the same way. Despite all those things, there are certain problems, of course, we are working at, but the preferences that are provided by the treaty require further procedural regulation. And as was already articulated about the pension security, pension systems, well, they are different, of course, but important aspect of integration is for the people to feel protected. For instance, when they relocate, looking for job, it's important for them not to lose their pension rights. And now they are not accumulated, they are just formed. And Eurasian Economic Commission, together with the bodies of the countries, have developed a certain agreement which would allow us to keep and implement the pension rights of the people at the same conditions and in the same scope as for the employment of the employer country. It's export of pensions and development of cooperation in pension providing. So the main principle of the contract is that the pension will follow the pensioner and not the other way around. So that will allow us to strengthen the social security of our citizens. And as I said, this agreement was signed by the Supreme Council and now is tabled for ratification to the member states. For this document to be operating, we have to adopt a number of documents regulating the activities of the competent authorities, and also to work at identifying the obstacles, and we are doing it permanently. So we also are working at the access of the citizens to the medical and healthcare, and providing them healthcare in very hazardous diseases like tuberculosis and AIDS, and also helping them find job in the places they live. And we are now developing a single internet resource looking for job without borders. So this is the first step of creating of electronic labor exchange. The citizens with medical, pharmaceutical, pedagogical, and should be registered and recognized according to the requirements. To simplify the employment of this category of specialists, we are working at a draft of specific agreements which automatically will recognize the scientific degrees and also directly recognize the education level. So those are the 4 exceptions that were postulated by the contract. So otherwise it is automatic. The analysis of the 5 years of activities and the best practices allowed the Commission to table an initiative to provide a special status of labor status to our citizens, which will provide their rights and freedoms for longer term employment in the same scope it is provided by their states. To upgrade their mobility, and we've agreed and aligned on the amendments to identify the purposes of their relocation, and if they need it for work, they have to change the purpose of relocation. So, colleagues, I should say that this major international integration union has the aim to provide sustainable development, which matches the goals of the sustainable development of the UN. So, and we should provide high quality education, partnership in the interests of sustainable development, gender equality, justice, and effective institutions are all related to migration processes in the Eurasian space. And every member states making the steps based on the national strategies and concepts of development of their countries, whereas the economic integration in the framework of the Union is an additional factor which facilitates the achievement of those sustainable development goals. And in this respect, the Commission also is working at, and we are planning to conduct a big forum, which it was articulated that this year the chairman goes over to Belarus, so we want to conduct it in Belarus, this forum. So we invite you or all parties concerned and interested to participate in the forum. It was already said that at the Supreme Council meeting in 2018 in St. Petersburg, the President signed a declaration on future development of integration processes, and currently we are working at the strategy of the development strategy development up to 2025. One of which is opening up the potential of integration and upgrading the quality of life of the citizens. And any modern integration facility or institution and Eurasian Economic Union is not just limited by only processes of trade economics. Now we have digital, social economics, scientific, educational, healthcare, sports, tourism, green technologies, and all are included. So now we have a number of ambitious tasks to master all those new directions and ways of development. And I don't know how to say it, but maybe we should jointly with the authorized associations and expert communities to build up the single Eurasian social space. That's at the level of idea, but how to implement it, we are still reflecting, and we are going to get the brains and advice of the experts to implement the idea. Well, the issues of harmonization of the legislation in social development, in introduction of innovative technologies, and as you know, we have a digital agenda up to 2025, and digitalization of our economies are now at the forefront, and we are working at that. And I should mention that currently interaction among countries in education is not limited only by the educational documents, so the level of education of the citizens impact their qualification, and is a consequence on the economic potential of the whole union. And to fill the gap, the promising aspect is developing cooperation in science and education, and we have to conduct an analysis and a survey of educational standards in our countries on the most advanced and demanded professions, to possibly unify them. That's the maximum goal, but at least to harmonize those requirements. And I think that's quite a doable thing. In conclusion, I would like to mention that the Commission does support the efforts of all parties concerned, working at the development of proposals to develop the single labor market and the recommendations of the best practices, including the spheres of legal regulation. And certainly, we're going to take all this into account by the Commission as a above national body to implement all those big ambitious plans. Would like to join in to my colleagues saying that our integration has taken place. It does operate. Well, of course, there's criticism and court cases, but that's relevant of all the processes. If you don't work, you're not criticized. That's what we can say. But at the same time, all the results and statistical data shows that all the member states have acquired a huge multiplicative effect, and we are trying to eliminate the barriers and limitations in our joint trade, which gives us an opportunity to grow further, to upgrade the well-being of our citizens. Thank you very much for your attention. Thank you very much, Askar Balatovich. Thanks to our colleagues from there. We now have an opportunity to evaluate their results of the 5 years of the work of the Union, and to find out everything about the legal department activities and court of the Eurasian Union. But the panel would not be full if we didn't have an opportunity to find out about the results of the scientific community. So I'm happy to give the floor to Anatoly Kapustin, first Deputy Director of Legislative and Comparative Law to the President of Russian Association of International Law, Doctor of Law, Professor. Good afternoon, dear colleagues. Dear members of the Presidium, I'm not going to enumerate them all because we'll lose time. So, colleagues, needless to say that Ekaterina has set a very large-scale objective for me. That's quite a difficult thing to provide this kind of assessment. It requires a special survey. But my objective that I have set for myself, well, there were several ways, maybe not three, but like the medieval giants used to have. What I can share with you, with my colleagues, out of all possible, and you know, I'm not the first deputy. I am a fellow or scientific advisor. So that's why it has changed a little bit. But but the business cards are out. That's it doesn't matter very much. But I am not here to provide assessments. We are analyzing and providing appraisals and conclusions. But colleagues, as for My objective, well, I was in the mindset of a very simple thing, methodological thing with two sides. Well, what a scientist can say, several realities we're in. The first one is the legal one, which our colleagues who are dealing with such issues, and they occupy specific positions in the authorities, and they are working with real normative acts, and they are applying it, they are interpreting them, and they are doing real work. They represent the real picture of work in the Eurasian Economic Commission. So shall I press the button to show the slides? Okay. So that's number one reality. The second one is, and we cannot negate it, well, you can call it virtual reality or abstract reality or scientific reality.
That's the reality we have in our brains of scientists and specialists who work with relevant questions. It might be different from the reality they have among practitioners. Yes, there is reality number 3 from people who never heard about all these things, but I would like to stress the second. So the second position, in my background, education, basic education, I am international lawyer, and my PhD, I have 2 PhDs, candidate and doctor of sciences, defended them on international law, first in integration and first in American and then European integration is the second. But nevertheless, integration and integration process, when we try to understand it, well, I see you have various backgrounds in this area, and there are those who work in social areas, social legislation and labor legislation, and other specialists. So we all have our own perspective over the processes going inside the union, and they are all quite logical and grounded. I'm talking from the point of view of international law. Why? Because my background is in this area, and I think that the heritage we have from the Soviet Union and the Russian science developments is still there, and we continue working on this from the point of view of methodology of research of various phenomena of international relations, including those of international organizations, is quite applicable to the EAEU as an international organization and the law that is being articulated inside it. Since this is quite well developed area, hundreds of discussions, and there are things that has already been established. But yes, there is some specificity. I will also touch upon it. There are various theories. No, I'm not against them, and they sometimes give us too one-sided assessment from their positions. Also quite logical, probably. But as international lawyer, I try to look at developments in various regions, and I understand that the same processes are going inside various other regions, not only EAEU countries. So I will not delve into details now on this, but I would like to... Can I have the next slide, please? Yes, here's the clicker. Very good. Where should I direct it? It doesn't work. Where should I... How should I switch the slides? Can you please help me with that? Very pity. So it's a pity. Where should I press? So first picture is the international law specificities of EAEU as an international regional integration structure. EAEU, I call it in a way it is articulated. The name from the text of the agreement. So last year it was 5 years since we signed the agreement, and this year it is 5 years it came into force. So as a specialist, I will try and not to interpret it, but I will try and find areas that, from my point of view, critical point of view, probably it's okay for science. I will try and assess how, in the most simple areas, what potential of development we have. I'm not going to repeat what the slide says. Can you see the text clearly? So good. First thing I wanted to mention is that I don't know whether the authors of the document actually aiming at this, but I highlighted 3 main areas and roles of the integration. As for the planned participants, this is the integration in the post-Soviet area. So yes, there is large Eurasia, including Europe and Asia and China, and there is small Asia, ex-Soviet Union area. We are talking about this smaller area, ex-Soviet Union space. But this is not all that simple. If we look into the agreement attentively, there is a paradox in it. For instance, Article 108 of the agreement. Joining the Union is open for any country. Any country can join the Union. Any country that shares the principles and goals on the terms agreed upon by the member countries. So if we take the agreement on the European Union, or for instance American or African unions, so usually such documents say that the member countries can come only from the region, relevant region, but we are open for every country. When we're talking about Eurasian integration, I would like to ask a question. For instance, if Egypt, it is the closest country, if they're interested, or Libya or South Africa, if they want to join the Union, will we look into this question? Or we can say we are just Eurasian Union. If we go to the court, they can say yes, it is possible that they join the Union because of Article 108. I don't know, but probably clarifications will come, but we need to define this point. For the short-term perspective, if we enhance the Union, last year a book was published and I analyzed the opportunities for competition of 2 law systems of EAEU and the European Union, and I suggested that with weakening of the European Union, probably in 30 or 40 years, we will have more opportunities than today. Probably we will cover the European Union. European countries might be willing to be part of our union. Well, it can be possible. I can theoretically imagine that. But for instance, as for Latin America or the United States, can they join the union? Well, probably in the short-term perspective, no, they can't. And we need to define this. Point number two, EAEU as an international organization for regional economic integration. What does it mean? I say that in the relevant science and the acts do not have such definition. In 2010, the monography was published, the monopolies in the globalizing world. In chapter 4, I'm giving the definition of this organization, and it is still relevant, and I support all the points articulated there. But the notion of regional economic organization is more than just intergovernmental organization, since what was mentioned already, the goals and tasks and the functions made by the bodies of the Union are aiming at joint economic space or the joint market. So a space covering the member states' territory. But intergovernmental organizations do not offer that opportunities. So regional economic integration notion is quite in line with all those things. But there are references, for instance, in a number of legal acts, international legal acts, they speak about an opportunity to join various organizations. For instance, the Vienna Convention of Protection of the Ozone Layer. Article 1 says regional integration means integration of sovereign countries of this region, those that are competent in the questions regulated by the convention. So the situation is that any organization can be defined as a regional organization for economic integration. And from this point of view, I think that science should fill the gaps of practice. And at the end, I will articulate my suggestion about the definition of the organization. I will give it later, but just the references for your understanding that not everything coincides with everything else. So EAEU is in line with all the criteria and characteristics of an international intergovernmental organization. So there is legal basis for it based on international treaties. I call it the Setting Up Act in line with the Vienna Convention, but there can be different names. So the agreement on setting up the EAEU is the main document, but that's not true. There is additional documents and the documents signed by Kyrgyzstan and some other member states. They signed when joining. That's very important to mention. Why we are very much serious about that? Well, the documents are of intergovernmental, interstate nature, and according to Article 109, only countries that share goals and principles can become observers. Autonomous organization structure. Any international organization can have bodies that do not depend on the member states, but member states can be part of such bodies. And legal autonomy. So any international organization, intergovernmental organization, is a subject of international law, can sign treaties and all that. I'm not going to enumerate all of them, and has competences and opportunities and responsibilities to adopt acts in questions and points that are given by member states into the scope of its responsibilities. I'm not going to delve into details on this slide, but next is... Did I skip one? No. Everything is right. If we look at EAEU, we already mentioned that. I'm not going to talk long about it. One of the goals is to create the joint market of services and capitals, and the principles are different from those. First, none of the intergovernmental organizations create markets. Markets can be created by arrangements like WTO or anything else, but here we are talking about creating a joint market. That's something that brings countries together a bit stronger than just the willingness to be friends. And then the Charter and other general principles, sovereign equality of countries and territorial integrity. I do not know why territorial integrity. I think sovereign equality is enough, but probably there are some doubts between countries, and that's why they articulate this principle. This is a general principle of international law, no doubts about that, and based and act on market principles, fair competition, and functioning of the customs union. So it means that this organization is not just an ordinary intergovernmental organization, but can be called regional organization for economic integration. And the last point on this. Sorry, it was too long probably. So these are the main peculiarities of EAEU as a regional economic integration organization. So I agree to what previous speakers said. The representatives of the court and the commission said that together with the intergovernmental bodies, the highest Eurasian Economic Council and Intergovernmental Council, there are two supranational organs, integrational organs as I call them, Eurasian Economic Commission and the Court of EAEU. why they are different one from the other. This is not just to create something new. In science, if we look at comparative aspects of research, of international law, legal research of various integration unions, there are usually two definitions: either international organization like a community, in the format of a community, economic integration, where supranational organs, bodies, do not depend on countries, member states, and now the delegation of authorities is very enhanced, is vast. And number two, organizations, well, yes, the word is the same, but those are mostly about the Latin American unions, and they think that they are a bit lagging behind the EU, for instance, and intergovernmental element is very powerful. But we have some similarities with Latin American unions, but integration aspect is important here. I'm not talking about practice, but scientifically speaking, if we look at the structure of the Commission, we have the Council. It is an intergovernmental organ, and there is lack of responsibilities the European Court has, the Court of the European Union, for instance, to make decisions for and mandatory interpretations. Our court lacks such authority, but it might come in the future. For this, we will need to introduce amendments into the charter. And just as a scientific definition, I'm showing here the definition of this particular regional organization for economic integration, that and the EAEU is quite in line with the definition and the law of Eurasian Economic Union. Couple of words about it. Here I show that the agreement basis is a bit wider than mentioned before, but there are some agreements, treaties that are still in force, probably temporary, but they are still there, and the treaty basis is a bit wider than it is defined in the Union. So these are the examples of treaties that work in the customs union, previous treaty. Well, first of all, customs union, and then the joint economic space and the protocol of functioning of EAEU within the framework of multilateral system. This is also a treaty that covers various regulations of WTO. We should not forget about that. Next, very briefly. Sorry, I skipped a couple of slides. And this is a slide about the treaty. So let's go to the certain elements. So here are the main characteristics of the Charter Treaty on EAEU. One of the most powerful, from my point of view, I'm just saying it, the slide doesn't have it. I wrote about it. I'm not hiding my position. I think this treaty is constitutional in its nature. It doesn't mean that this is an equal document equal to constitution of the whole Eurasian Union. It is dangerous to say this, but this is a system-setting factor in the law of the Eurasian Union. In this legal system, and this add-on, this is a constitution-like factor. Otherwise, we might have questions whether it is in line with the constitutions. If we say that it is a constitution, probably it's higher than other constitutions, but no, it just plays a very important role. I'm not going to go to the details and cases now, but there are programs of regulatory nature for development of various points. For instance, now the protocol is being prepared, colleagues, probably you're aware of that, introducing amendments related to oil and gas markets. So the Charter Treaty is developing it. It is not just standing still. Next. Characteristics, I'm not going to touch upon it. Already mentioned all that. Nothing interesting about it. And here I would like to support what has been said by colleagues about the narrow and wider understanding of the law of the Eurasian Union. So it's Article 6 and outside of Article 6. So it is in the appendix related to the EAEU Court. Can we say that other, not mentioned by Article 6, other regulations are regulations of this particular legal system? So very good cases were articulated. I'm not going to repeat, saying that the court is applying the general rules of international law and other international treaties that are not enumerated by, touched upon by Article 6. I think that the rules of soft power and the decisions of the court, and I'm sure of that, and I'm happy that we have in this supranational level, we have different opinions. Of course, decisions of the court, and in the document it says that they are mandatory for the member states, for the parties, and only for the specific disputes. That's the position or provision which is typical for such documents, but these decisions became legal positions that became part of the wider body of the law of such international organization, and here is the same situation. I'm not going to delve into details now on that, and I will finish my presentation because Ekaterina Sergeyevna is looking at me very sternly. Last thing. Moderator has its own privileges, I understand that. So this is a definition. But my main point today is that this is international legal structure. Yes, of course, if we look at the methodology of research of law of international organizations, yes, usually in some cases it is different, but usually organization of internal activities of an international organization. As for member states, everything is done through international treaties. In a part today, this characteristic is, as it was properly put, is the dominating one. That's why I think that this is an international law notion. Yes, there are other sources of such content, but we today should think about development of the law system of Eurasian Union on the basis of international law. Thank you very much for your attention. That's it from me. Anatoly Yakovlevich, thank you very much for your presentation. I'm giving the floor to Deputy Director of Institute of Law and National Security, Valery Alisievich Smirnov, for your presentation. I will have a short presentation, and it relates to the prospects of development of the Union. I would like to follow the idea of Zholymbet Nurahmetovich about the fact that wherever we go, for many people, Eurasian Economic Union and the Court of EAEU is not a well-known notion. I'm not talking about foreigners. I'm talking about representatives of our 5 countries. For 5 years, we've been cooperating in development of the Union. So that's the main task, I think, for the Commission for the next stage. Starting the 1st February, the Commission will change, and the chair is going to the Republic of Belarus. So the awareness raising about activities of the Union and the Court of the Union and the Commission. And when we planned this session, it was one of the tasks to raise awareness for those who know about all these bodies to know more about it, and for those who do not know about us, just to articulate this information. The Union and the Court are developing, and they have their own responsibilities. We talk a lot about questions of education. In October, we had the Eurasian Week in Bishkek, and we have a special panel on education in Eurasian space, and we see that among 5 member states in integration processes on the basic higher education, no one is working in this. Only master's programs, both in law and the economics, various aspects in the Higher School of Economics and International Relations University in Moscow, and we also talked to universities from Kazakhstan about the results of 5 years and the prospects. I can speak about what contribution we made as the Institute for Law and National Security. For a couple of years, we were developing bachelor's program for lawyers, international lawyers, and it's great to hear from Anatoly Yakovlevich that he is international lawyer in his background. We developed a special program for bachelors, the law in global integration. It is aiming at development of talents for Eurasian Union, for the Commission, and for other bodies, government bodies of member states, and in the future probably for the Eurasian Court. This program started last year. This year we had the first enrollment procedure, enrollment campaign, and this is a unique program indeed. If colleagues want to talk about it and share experience, you're always welcome. This is the first step, because in Bishkek we also discussed points related to lack of harmonization of education. You know, questions of science and education is outside of the scope of competences of the Commission. Still, is it possible to harmonize education space without having the provisions of the treaty as a basis? I think no. I think that in the coming years, as academic community, we expect that the amendments are made into specific agreements that regulate the recognition of diplomas, of certificates, and the approval for permission to work in other countries, member countries, without nostrification of the document. But also, it is important to cooperate in educational programs. Let's talk about a format like, we talk a lot about the experience of the European Union. Probably within the framework of Eurasian Union, this can be our own Erasmus+.
Хотя бы в ближайший год, потому
in the coming year, because it's absolutely important to interact between the pedagogical, scientific community and the students. And the second step, I hope we will finalize tomorrow. Tomorrow in the Academy, in the framework of the Gaidar Forum, we will be joined by the chairman of the Eurasian Commission, Mr. Sarkisyan, and we will make the next step for the prospects of development in education. And we are to sign an agreement to set up a basic chair of, which is going to be the first one on the basis of our Academy, the first one in the 5 member states. As of tomorrow, it is going to be a fact, which will give us an opportunity both for the postgraduates and students to have internships, and also for acting specialists, and I hope for the court judges also to be involved in the activities of our academy and the qualified personnel preparation. Thank you. Thank you very much to every speaker, and I will remind you that you now have an opportunity to ask questions, and I will invite our panelists to use the microphones. Please, you're welcome with your questions. Microphone, please. Partner of yes, Mr. Kapustin, correct me if I'm wrong. You said that the members of the Commission can become, European countries can become members also. Yes, that's correct, because Belarus is a European country, by the way. Russia, of course. I mean, those who belong to European Union, why not? Of course, yes. As for European Union, it's much more difficult. The current members will hardly do it because they have limitations to participate in other treaties. If a state concludes a similar agreement or joins an organization which shares the mindset and the same principles and standards, then they will not be able to accede. So we are softer, but, well, it's not desirable, of course. I would dispute, I would argue, because when the Commission was set up, the mindset was that only the countries can join that used to be part of the former Soviet Union. But I think that was strictly followed, and it is. Yes, I understand, but no, one thing is when you forgot about, well, sort of, it was all very good on paper, but the contract, the treaty with supreme legal force, well, explicitly it is written that any company which is this provision is characteristic of any international organization, UNO and others. So if no European country would want to join our union because they might not share our principles, well, of course, they are not forced to do so. But we should have postulated that European or Eurasian states. But why I drew the attention to that it can happen because we live in the epoch of postmodernism when. Well, now it's Boris Johnson and others. Previously they are doing things that he's the premier now, and he would have been punished for all those things in the previous times. But Venezuela, for instance, if they would like to join in. So I mean that the word and the norms and the conditions and setting the procedures of joining an international organization, it is imperative. You cannot interpret them otherwise. But I believe in their reason. Maybe they would interpret it differently. Thank you very much. More questions? You're welcome. And then you, and then you. Good evening. My name is Remin Andrei, partner of law firm. My question, practically, I think that we did have some cases, and we can hear from our clients that national authorities of member states sometimes deviate from the norms that are adopted at the level of the union, and it creates problems for business. For instance, if you got a certificate in one country, which for some reasons the other member state does not recognize, or maybe some other deviations from the general union norms. But my question is about, it is to all the panelists. What are the instruments is provided by the legal system of the Commission to address such issues and exclude such cases of deviation from enforcement regionally from the union legislation? Thank you. Correct me if I'm wrong. It is a question to all the speakers, right? Who is ready to answer? Well, as you said, if there is deviation, of course, if you mean the single enforcement, there's several ways to do it. One, if it is done as in the way of decision, which covers the interests of all the companies, that they can go to court to challenge. And the second way, the Eurasian Commission has such a function as the control and monitoring of enforcement of international treaties. Specific companies, they can also address Eurasian Commission to say that this treaty is applied differently. In Kazakhstan, they do it this way, in Russia, another way, and even the law enforcement and court do it differently. Please monitor the enforcement of this international treaty and then make some measures. And they are entitled to monitor, to introduce prescriptions or rulings to enforce. And as I said, there might be some other mechanism. They would go to court to make it legal. But even if, recently there was a case, it is now pending. There was a claim about monitoring it was about customs, and Eurasian Mission said that the decisions that were made are not in our competence, and we will not revise it. And they wrote it, oh, please monitor and not revise it. So you deviated or refrained from monitoring. They addressed us and they said, please recognize their lack of activity. So I don't know how they're going to solve it. One of the mechanisms is as such. It's clear. Thank you. Well, the mechanism, of court is a punitive mechanism, of course, but there are some pre-court procedures, and the Commission, of course, can provide its opinion if indeed there is a barrier, and if it really complies to the treaty, well, and the normative base that the countries have signed to. So, for instance, saying that those are the exemptions. For instance, for them saying that we are not ready to integrate in this or that sphere, and we cannot do anything unless this exemption is eliminated, and so on. But there are some spheres which are not regulated by the normative legal base, and there are cases when this or that norm does exist, but the competent authorities make contradictory decisions. Then, in this case, the Commission has an authority to submit this to the meeting of the Collegium and to review it as an obstacle or a limitation. And if the Commission pens that there's a gap, then they will have to work at eliminating or filling the gap. If if, for instance, there exists a normative base to regulate this or that sphere by a national act, but the national act violates the union norm, then the Commission, having provided certain procedures, having recognized and established that that's a barrier, and the certain procedure is done, then it is submitted to the Collegium to further notify the country to eliminate the barrier, and a certain term or time frame is provided, which is an inseparable part, and the country is to eliminate the barrier. And the Commission does have this kind of authority. Just a couple of words, because it's a very broad sense, but of course you cannot cover all the aspects here. From the point of view of legislative process, 2015, when the treaty became valid, the procedure introduced a provision. It used to have an article saying that while preparing the drafts, you have to do an expertise on compliance of any draft law to international treaties. And there was an additional article and provision saying that during the expertise you have to double check its compliance to the Treaty of Integration and other agreements. So this provision, we as an expert organization providing expert opinion, and every draft law provides this kind of thing. So in the recent 5 years, I can say that there were 3 cases then in the process of legislative activities and developing a draft law. There were situations of collision with the law or of Eurasian Economic Commission. And first, when it became valid, it turned out that for some of the positions of an agreement, and for instance, there was an agreement about pharmaceuticals and their turnover of medical goods. It so turned out that the states had not been ready, and they didn't have enough time to adopt certain documents by the end of the year for those agreements to become valid. And there was a huge problem because that was about the old market with all old rules, and that meant quite a big sum of money. And At that time, the decision was made to postpone. I don't remember. I think that legally it was not somehow a provision, but unless the commission finalizes the work, well, there were several situations, not many, but a few. The second one, well, the authority, the legislative authority or institution, well, it was mentioned here that education is important. So we should introduce a course in universities, the right and the law of Eurasian Economic Union. Because unfortunately, lawyers and law firms and legal departments of companies meaning, well, they just don't notice those agreements. For instance, when they write negative conclusions saying that this does not comply to the treaty of the Eurasian Union. Well, and there can be two situations. First, when our legislation doesn't have it, but the norms do. The regulating certain or acts of the Commission regulating certain areas, and they do have a definition of some procedures. And in some of our departments and ministries, they just think that they should reproduce this definition. For instance, there was a problem now with the law on polar protection, and well, and there was the same, and it was sort of ambiguous position because some of our specialists think that that's not bad if it is duplicating word for word of all those norms. Some think that it's not worth doing because the norms can change. And shall we change the legislation every time? Maybe it's too short-sighted. Well, in number 3 situation, when they didn't take into account, well, of course there are nuances, and there are situations sometimes. Then in our member states, some norms are not adopted, and we are trying to sort of accelerate. But our position is very tough, that they should not adopt it because that would contradict with the treaty, and all those procedures might be in place about the court and Eurasian Commission, colleagues mentioned. Thank you very much, colleagues. Just three questions, and we will have to finish. Please, briefly, and speakers also, please be very brief. So let's do it this way. You hear from you. Please use the microphone. My name is Gelka Moldova, Doctor of Economics, a lawyer and prosecutor for many years in the prosecutor's office. A very important panel for many questions for CIS and Eurasian countries. Just for your info, currently we have a new general prosecutor, a very smart person, and in the Supreme Court there are a lot of changes and well, question, please, your question. So there's a wish that I would wish that for Eurasian Commission and the materials of conference maybe talk more with CIS countries, because many are unaware of all those things, and I would wish that the materials, because the materials are very serious here, for them to be circulated to the legal departments of CIS countries, for them to learn and be more active interacting legally. That's my recommendation. Why I'm saying all this? Because last year I visited one forum in the Ukraine, and it turned out that they were unaware of some Moldovan and other issues. And in my understanding, we should be interacting more broadly with Eurasians and CIS facilities. But otherwise, a very good event. Thank you very much. And one more question. Tigran Aganisyan, researcher. It's a question to Zholymbet. You said and you stressed the necessity of well, the president today proposed to introduce an amendment to Article 15 to have an opportunity to limit the norms of international law. Well, the question: don't you think that in the future some of the member states would not fulfill the decisions? Well, there are precedents when the norms of constitutions are higher than justifying that the constitutional freedom is violated. Possibly, yes, this mechanism is well settled, but there's one but. The constitutional legal freedom the constitutional courts refer to usually, more often than not, they are dealing with physical rights, but we are talking about economic rights, and we are not afraid of that. And as I said, well, if you look at the treaty, the ruling or the injunction of our court is mandatory for or the states, for the member states. And as was said, the international agreements are fulfilled. They are enforced, and the courts and ministers of justice, they well, I would not say that that's mandatory, but they know that that should, because otherwise they, if they don't do it, then any other company would address us, and we will said that it is not compliant with international laws. Well, preventatively they do it. Thank you very much. And the last question from here. Professor, Russian Academy. It's RANEPA. Very interesting statements and presentations. Thank you very much. Just a couple of questions. I would disagree with the assessment of the chairman of the court that no one's aware about the court, because in the framework of our master's degree program, we do have a special subject and topics devoted to the court of Eurasian Commission. We are even studying the legal positions, and our students are aware of it. And your presentation was very interesting. My question would be, because the rights are developing and the court is looking for its place to be occupied in the legal system, how often do you have cases of special opinion of judges? And do you think that this special opinion is a very important mechanism of developing the law of Eurasian Commission? And the second question about alternative procedures of settlement. Mediation. Did you have facts when judges reviewing? You said 13 cases you had. When they used mediative techniques and technologies, finished the case, and they sort of with mediative methodology, and for it to be more effective, the settlement between the briefly, a special opinion and state again versus state, 5 special opinions, and we made a decision. Special opinion is provided not only for the substance but for the motivation. Practically, there's no case without special opinion, and then special opinion is a very frequent case, and you can look up for in our website. Any lawyer and any has his own opinion, but that's only opinion. It's not a ruling of the court and not an injunction of the court. And those who adhere to it, that's up to everyone. Well, that's their right. Now about mediative agreement. The case postponed till 21st of January. We gave them 2 months to discuss the amicable agreement. If they come to say that they have got aligned, we will be happy to finish the case, to stop the case. Well, and we do have it very often when we propose to have an amicable agreement. If not, then we can review it. Okay, dear colleagues, 2 hours have passed unnoticeably for our panel, and I am declaring the finish of it. So thank you very much to the speakers, those who ask questions. And I hope that next year we will have a question on the prospects of development of Eurasian Commission on the agenda next year. Thank you very much.